Good morning.
Good morning.
All right. If you would all stand, raise your right hand so I can administer the oath. When I finish reading this, if you will respond with I do or I will. Raise your right hand. Do you solemnly swear or affirm to well and truly try the issues that traverse herein, joined between the state of Tennessee and the defendant Hernandez Govan, upon a true bill of indictment, charging him with the offenses of conspiracy to commit first-degree murder and first-degree murder, a true deliverance make, and a true verdict render, according to the law and evidence, so help you God?
I do.
Thank you. You may be seated. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of these proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and the judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching your decision, but now I simply want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant has pled not guilty to these charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorney's arguments, and instructions of the law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, the defense may make an opening statement if he so chooses. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal proof, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. Likewise, in closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, I will excuse the alternate jurors, and the final 12 jurors will leave the courtroom together. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described to you in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at your verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, a defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decision on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified from one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence, which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own understanding during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in the case. Please do not talk with them about any subject matter whatsoever. If you see anybody in the hallway or at any other location, perhaps the best standing rule is to not say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. I do not know if there will be any media reports in the newspaper, on TV, or any radio about this particular case. I think there may be. If there are, you are not permitted to read, watch, or listen to these reports. You as jurors must base your decisions solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection for a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence. You must not decide the case. You must decide the case on the evidence presented to you. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for us all. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. We will now proceed with the reading of the indictment. So you do have note pens and papers. You're sitting on them. They should be under your cushion.
Indictment number 2204769. State of Tennessee versus Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, Jermarcus Johnson. Indictment for conspiracy to commit murder first degree, Tennessee Code annotated 3912103, Sketch Code 31015, Tennessee Code annotated 3913202, Sketch Code 21015. Witness F. Frias, MPD, summoned for the state. J. Browning, Multi-Agency Gang Unit, J. Browning. A true bill signed Mayor Bernard, foreperson of the grand jury, date indictment returned November 10th, 2022. State of Tennessee, Criminal Court of Shelby County. Shelby County, September term 2022. Count 1. The grand jurors of the state of Tennessee, duly selected, impaneled, sworn and charged to inquire for the body of the county of Shelby, Tennessee, upon their oath present that Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, Jamarcus Johnson, between June 1st, 2021 and March 1st, 2022 in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, with premeditation, and with the intent to commit the offense of first-degree murder as classified in Tennessee Code Annotated 39-13-202 against the person of Adolph Thornton Jr., enter into an agreement with each other to commit the said offense, that said Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, and Jamarcus Johnson, acting for the purpose of promoting or facilitating the commission of the said offense, and agreeing that one or more of them would engage in conduct which would constitute the said offense. In furtherance of the conspiracy of the said conspiracy, one or more of the parties to the conspiracy committed an overt act, to wit, Justin Johnson, also known as Straight Drop, traveled to 2370 Airways Boulevard and killed Adolph Thornton Jr. Cornelius Smith traveled to 2370 Airways Boulevard and killed Adolph Thornton Jr. Hernandez Govan solicited both Justin Johnson, also known as Straight Drop, and Cornelius Smith to kill Adolph Thornton Jr. Jamarcus Johnson aided in Justin Johnson, also known as Straight Drop's, hideout and escape after the killing of Adolph Thornton Jr. Aided communications between Justin Johnson, also known as Straight Drop, and Cornelius Smith after the killing of Adolph Thornton Jr., and facilitated payments to Cornelius Smith for the killing of Adolph Thornton Jr., all of which is in violation of Tennessee Code Annotated 39-12-103 against the peace and dignity of the state of Tennessee, signed Steve Mulroy, District Attorney General, 30th Judicial District. Count 2. The grand jurors of the state of Tennessee, duly selected, impaneled, sworn, and charged to inquire for the body of the county of Shelby, Tennessee, upon their oath present that Justin Johnson, also known as Straight Drop, Cornelius Smith, Hernandez Govan, on November 17, 2021 in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, intentionally, and with premeditation kill Adolph Thornton Jr. in violation of Tennessee Code Annotated 39-13-202 against the peace and dignity of the state of Tennessee. Signed Steve Mulroy, District Attorney General, 30th Judicial District.
Mr. Govan and counsel, how do you plead?
Not guilty to both counts, Your Honor.
Thank you. Okay.
Good morning.
Good morning.
We met last week, but for formality's sake, my name is Iris Williams, and I represent the state of Tennessee. When I was a kid, one thing that my mom always told me is that there are few things that we can control. But one of those things are our choices. Our choices can move mountains. Our choices can get us into trouble. And our choices can mean life and death. Ladies and gentlemen, this case is about choices. You're going to hear a lot of evidence this week. You're going to hear a lot of names. But the name that I want you to remember is Hernandez Govan. And I want you to remember the choices he made. And even more importantly, I want you to remember the consequences of those choices. Picture this. November 17th, 2021. The victim, Adolph Thornton, and his brother. They pull up to Makeda's cookie shop on Airways Boulevard. They park the car, they get out, they talk to the cashier, and seconds later, a white Mercedes pulls up and Adolph Thornton is gunned down and killed. You'll hear from Dr. Juliet Scantleberry, the medical examiner in this case. She'll tell you that Thornton's body had around 20 gunshot entrance wounds to his neck, his chest, his arms, and a catastrophic injury to his face. But how did we get here? How do we start? Where will we begin? This trial will begin with Erica Thornton. She'll tell you that she is Mr. Thornton's sister. She'll tell you about the last time that she saw her brother alive. And she'll tell you when she heard that he was gone. And after Ms. Thornton testifies, you'll hear from Mr. Raul Hopkins. He'll tell you that he worked for security for Thornton for years. And Adolph Thornton just wasn't Adolph Thornton. He was known across the city as Young Dolph, a musician. His music, his artistry, his journey, his ambition inspired and spoke to this city in ways that a lot of artists just couldn't do. Thornton made his own way in the music industry, and he created a label called PRE, Paper Route Empire. Hopkins will tell us about it. He'll tell us that Adolph Thornton made his way in the music industry and created opportunities for other artists. But when you create opportunities for others, some people don't seem to like that. So Hopkins will tell us about another label, CMG, also known as Cocaine Music Group. He'll tell us about the history and the tension between these two labels. He'll tell us that CMG wanted Thornton as their own, but when he decided to pave his own way, when he decided to be self-made, he became CMG's enemy. Hopkins is going to set the stage for how this story truly began. And after Hopkins, you'll hear from Cornelia Smith. And this is when it all will click. Smith is a co-defendant. He'll tell you that he met Govan in 2021. They met through Smith's friend, Bobby Carter. And Smith has a couple of nicknames for Govan. He calls him Big Bro or Quet. Govan started out by selling drugs to Smith, pills more specifically. But that's not the only thing that Govan did. Govan chose Smith. And Govan chose him to do a job. Govan also chose Justin Johnson, another co-defendant, to do that same job. A job that ended in the life and death of Adolph Thornton Jr. he chose two desperate people. Smith, needing money, needing to support his family. Justin Johnson, an aspiring and up-and-coming rap artist that wanted to be on CMG's label, the very label that Govan had access to and was affiliated with. Smith will also talk about a meeting at Govan's house. The people present at that meeting were Smith, Govan, Justin Johnson, and Anthony Mims, also known as Big Jook. Now, Jook is the number 2 person at the CMG label. Smith will tell you that Govan said that there was a bounty on Adolph Thornton's life. In fact, there were multiple bounties on PRE artists. Govan told Smith that there was a $100,000 bounty on Adolph Thornton's life, and that the money was good. The money was guaranteed if Smith and Johnson completed this job. So what did they do? What did the two desperate people do? They agreed. And Govan asked for a $10,000 cut from each of them. He chose to ask for this cut from each of them. And one thing that is important to note is that Smith and Johnson didn't even really know each other, but they knew Govan. Govan was the link between them. So let's fast forward to November 2021. Smith hears that Thornton and other PRE artists are in town. It's Thanksgiving time. PRE often hosts turkey drives at different locations across the city. So they knew that they were around. Justin Johnson picks up Smith from Smith's father's house, and they go hunting. They get to a stoplight on Airways, and at that stoplight, they see a special car pass through. And what is that car? A blue camouflage Corvette. Most people in Memphis know that there's only one person in this city that drives that car in this region of town. Adolph Thornton. So what does Smith and what does Johnson do? They follow that car. They follow that car. The car parks at Makeda's cookie shop. And seconds later, Smith and Johnson pull up in a stolen white Mercedes, gun down, and kill Adolph Thornton Jr. in broad daylight. They get back in the car, speed off, but not before Thornton's brother, Marcus Thornton, fires shots and shoots Smith. So Smith and Johnson are in this stolen white Mercedes. But where do they go? They go to ditch the car. They ditch the car, and we'll hear from Sergeant Dabney that the car was left at 1174 Bradley Street, which they later found out is directly across the street from the defendant's home. After they ditch the car, Cornelius Smith and Justin Johnson go to an apartment complex to change clothes and clean up their rooms. Cornelius notices something. He doesn't have his phone. He realizes that he left his phone in the white Mercedes, the murder car that they left across the street from the defendant's house. So what does he do? He uses Justin Johnson's phone to contact his own girlfriend, Angela Arnold, and you will also hear from her. You'll hear from Angela Arnold, and you'll hear from Cornelius Smith that she picked him up from that apartment complex. When she picked him up, he told her what happened. He told her that he was hurt, and he told her that he was missing his phone. So what did he do next? Smith contacted Govan from Angela Arnold's phone and asked to meet so he could get his phone back. Ladies and gentlemen, there are copious amounts of phone records, and Sergeant Browning will testify that these call detail records will support what Smith is saying. And if that's not enough, Angela Arnold will tell you that she and Smith met with Govan after the murder so that Smith could get his phone back. But that's not where it ends. Smith will tell you that at that exchange, Govan gave him money to buy a car cover, to hide the white Mercedes, to hide the murder car that was parked directly across the street from his own home. Not only that, but the day before Cornelius Smith was arrested, he ran into Govan. Govan was concerned. Govan was worried that Cornelius Smith had not been paid. And so what did he tell Smith? He told Smith that he was going to go to Privé to make sure Smith got his money. Privé is a lounge and restaurant that's affiliated with CMG artists. Ladies and gentlemen, choices. A choice to get two desperate people to agree to murder Adolph Thornton. A choice to guarantee them money. A choice to ask for a cut of that money. A choice to help one of the killers get his phone back after the murder. A choice to make sure that one of the killers got paid after the murder. Choices. When you hear all of the evidence, and when you hear all of the videos and look at all the photos and exhibits, you will see the consequences of Govan's actions. Violence, death, loss. A man, a human being, taken from this world in one of the most shocking of ways, getting cookies for his family in broad daylight in his neighborhood during the holidays. At the end of this week, the state will be asking you, the jury, to make a choice. The defendant is charged with conspiracy to commit first-degree murder and first-degree murder. Last week in jury selection, we talked about theories of conspiracy and criminal responsibility. And once you have heard all of the evidence, the state will ask you to make a choice and find Hernandez Govan guilty of first-degree murder and conspiracy to commit first-degree murder. Thank you.
Switch the screen off.